Morning, Chair. It's 9 o'clock now. We do have about 6 members, and then the Department of Home Affairs is here in attendance, and Parliament leaders is in attendance. Thanks, Chair. Back to you.
No, thanks very much, members. I'm sure I'm audible.
Yes,
Yes,
Chairperson, you are audible.
Thank you very much, Honorable Machi, and good morning, honorable members. Good morning, the Department of Home Affairs, the Parliamentary Legal Services that are responsible or will assist the committee on the bill, the Chief State Law Advisor in attendance. Last week, we received a detailed report or presentation on the SIU and counter-corruption unit, including the multidisciplinary team, on the issues that the 3 teams have been involved to curb corruptions in the Department of Home Affairs. And the meeting, as a reminder, considered to further facilitate a joint meeting with Labour, Higher Education and Tourism to further engage on the recommendation, but also to share notes on the report that has been presented by these joint stakeholders. We will facilitate that session in the fourth quarter so that these other committees also familiarize themselves in terms of the issues that are rising and possibly on the need for amendment to the legislation that is currently facilitating these areas of concern. I must indicate that members, as you know, that Honorable Mohammed has not been joining us in the meeting, both physically and virtual. I've interacted with her. I must indicate that she's not well, as we've indicated, and request all our members to give support to Honorable Mohammed and with prayers and hope that she'll recover. During the 6th administration, the IEC proposed an electronic voting as we are approaching to the elections, and the committee interacted with that proposal. We could not agree with the IEC because they've not solicited views from South Africans or a study that was conducted. We then, as a committee, agreed that the Independent Electoral Commission must proceed to conduct a study, which they did. As you know, last year, they've proposed a policy discussion document around this electronic voting. The committee then resolved that they will conduct also a study to countries or member states that have facilitated electronic voting, including those that have failed on this electronic voting. We have commissioned a proposal of countries that we must visit. And you know that we identified Brazil. On 2 occasions, we could not proceed to interface with the Brazil because of the failure to pay more attention to the legitimacy of the issues that the committee is going to deal with. We again have interacted to propose to go to another country, which last week we've received a report that members of the committee were not convinced on. It will suggest from the report and the issues that are rising from members that the subject matter is quite crucial for the committee to interact with. But on the part of those that are responsible to facilitate or to prepare, it will have appeared that there's no urgent attention, no consequences that the Parliament exerts on members who are responsible to facilitate or to coordinate the study tour. It must be noted that the study tour is not only for a trip or members just want to go a trip for leisure, but was occasioned by a point that was raised by this committee and also engage with the Independent Electoral Commission and subsequently the proposed policy discussion document that the IEC is currently engaging on and possibly the bill that will be presented to the committee. It is for this reason that we've seen that and observed that there's a lack of appreciation and the decorum on how the committee may need to be assisted on the subject matter. On your behalf, I formally engaged a formal complaint with the COC on the issues that I've highlighted earlier on, and there must be engagement. Part of the issues that I've raised with the COC is to get other members of the staff of committees that must join the Portfolio Committee of Home Affairs to both assist in terms of its overall work of the committee, including facilitating this study tour, both of what you have agreed on, members of the study tour on the one-stop border post that we have agreed that we need to engage before July. You know that it will be impossible for members to go out as you approach local government elections. So the period that we ought to facilitate this study will be not closer to the preparation for the local government election, because members will be engaged in various responsibilities given by the political parties. But I'm sure even Parliament may not allow public representative to go out without engaging on the on the local government election preparation. So it's for this reason that I have to note to the members that we have taken this seriously, and the concern that had been raised in our last committee meeting, in the manner the report had been presented and also communicated to members. We've also continuously doing our work outside the framework of those that are responsible to make sure that we regain the lost ground. But Honorable Frolik and his team will able to interact with the officials that are responsible for the Portfolio Committee of Home Affairs. Public hearings have concluded, and we have received a draft report. Again, that draft report, members of the committee had concerns in terms of some of the issues that were not sufficiently covered. We have requested the content advisor to rework the issues, but also the Department of Home Affairs, because they were also interacting with us throughout the public hearings. We've then agreed that they will present to this portfolio committee meeting the reports and the responses that have also been sent to the department in relation to the draft report. The program indicates that we'll adopt the contact advisors report, will not adopt the report today. We'll only note the report and give members an opportunity to go and interface, including the responses that we'll be receiving from the Department of Home Affairs, so that when we adopt the report, all of us were clear on the issues that have been presented before us, and were able to deal with them and engage with members of the committee. It will be proper that we afford an opportunity for members to interact with both the report of the Department of Home Affairs in terms of their responses, but also on the issues that have been captured by the content advisor, so that when we interact with the subject matter as a committee, we're then able to get an advisor in terms of the issues that we might have outside the framework of the process that we've been engaged on. We are aware that there are critical issues that members of the public have raised to the public hearings, those that fell outside the framework of the Constitution, but those that are within the framework of the Constitution that the committee may need to engage in detail. With those words, members, I will then invite, if there's apologies from Mr. Matonsi, and introduce those that are in attendance, including our stakeholders. Mr. Matonsi.
Good morning, Chair. From my side, I've got an apology from the minister. Besides that, part of my honorable. Thanks, Chair. That's all.
I've requested that introduce those that are in attendance, stakeholders. Thank you.
Now, what we have in the meeting, Chairperson, we have got the Department of Home Affairs, and the Parliament Legal Service.
Sorry, Chairperson, I will request that the Secretary should raise a little bit the voice, please. We can hardly hear you.
Oh, okay. Can you hear me now? I was just saying the people that are in the meeting is the Department of Home Affairs and Parliament Legal Service, especially for the response by the Department on the marriage bill.
Noted. At least if you can see how you manage your, I think the speaker or something, it disadvantage members to get clarity. Is the Home Affairs and Legal Service of Parliament that are in attendance? Can you move to the correspondence item number 3?
Yes, Chairperson, from my side, I've got a letter from the House Chairperson regarding the processing of legislation. The letter was sent on Friday to committees that have got bills before them. And then with us here, they have indicated the marriage bill, the one that we're dealing with now, then also the Electoral Commission bill, which is the private members bill that was introduced in 2023, and that today we should be providing the House Chairperson with a legislative program for the two bills on how we're going to process them. And then we have done that yesterday. We just need to share the draft program with the Chairperson today after the meeting.
Noted. Is the only correspondence we have.
Yeah, that's the only correspondence that deals with the legislation. Yes.
There's no any other correspondence in relation to the electoral reform panel?
I thought you mentioned that I must only deal with the correspondence from the House here on your website.
No, I said legislation. It's part of the legislation.
Okay. Okay, there is also I didn't have it here. I'm not going to be able to project it because I didn't have it.
Chair. Sorry,
yeah.
sorry. Good morning, Chairperson.
I'll come back
sorry
to
I'm sorry for disturbing. We really can't hear Mr. Matonsi. It gets muzzled. I'm not sure his speaker. We really can't make out what he's saying half the time.
Oh, okay. Let me just try.
Mr. Adams, can you take over, please? Thank you.
Yes, I can, Chair. Yes, last week we also received the correspondence. Eddie has the letter that the Electoral Reform Panel has tabled its final report after us telling the Reform Panel to go back to its to be reconvened after the minute, and then the minister in turn indicated that the panel had been reconvened. And they have now submitted the final report, and it's for the committee to now decide how to proceed with that final report, which will eventually also lead to electoral legislation, as the chairperson indicated.
Okay, let me advise how we're going to interact with. We'll meet at MENCO with the legal team of Parliament and work on the draft responses. I know that today is the last day to respond to the speaker. We can respond to that, but we'll meet with the legal team to process all the issues that has to do with the work of the committee in relation to the legislation. And you know that IEC also is bringing a bill to the committee, and how we're going to also to interact with the select committee of the NCOP as by the correspondence of the House Chairperson. We'll bring the report on Thursday when we meet with the Border Management Authority in preparation for the local for the Easter weekend, and members will then comment whether we'll able to reach the timelines that will have been established. And the legal team will also assist us, including the possibility to approach the Constitutional Court in relation to the extension on some of the bills that we're doing. Members will that assist as an approach and will give a report in a virtual meeting when we meet with the Border Management Authority on Thursday. Can I get an indication from members?
Chairperson?
Chairperson,
Eddie, it seems the chairperson
Yeah.
is frozen. Perhaps we could suggest we count the video.
yeah, if Ms. Mudisa, if you can take over until chairperson is sorted.
There's a hand from Honorable Ruiz.
Thank you. My background is not proper, but we can continue. I saw the hand of Honorable Bruce, and that's the only one. Then I heard Ms. Matthew also asking for the attention of the team. In that order, Honorable Bruce and Honorable Matthew.
Thank you. I just wanted to support the proposed way forward by the chair. Thank you.
Thank you very much, Honorable Bruce. Honorable Matthew.
No, thank you, Chairperson. I was of the same idea that we move with the directive by the Chairperson. Thank you.
Thank you.
Thank you very much. Oh, it's right, Chair. Okay. Thank you.
Challenge with the Thank you very much. And then can we now invite the content advisor?
Thank you, Chairperson, and good morning, honourable members. Yes, we sent this revised report of the electoral, the marriage bill, public hearings and public participation. The more extensive report is based on the presentation that I presented, which in turn the department has responded to subsequently. So I won't go into too much of the detail. The members have had the report and the department will be responding. But just to indicate that in total, we had an oral only testimony of 876 submissions, of which 37% were in favor of the bill, 43 were against, 43%, and then 20% were partially in favor of. And then we received an additional written testimony, predominantly from the Muslim community, over 700 of those, and the conservative Christian organizations, which, when considered together with the oral, changes the sentiment somewhat. But it is a bill that was primarily also initiated from the Concord case relating to Muslim marriages, so that stands to reason. In total, then, the total amount of submissions are 1,761, which pushes the sentiment more away from the bill, and as 70% are against it, 20% for the bill, and 10% partially for the bill. And then, yeah, this is just a graphic representation of how the verbal and oral and then combined testimonies can be seen. Again, like predominantly against in terms of the written submissions, and then a more of a balanced perspective when looking at the more oral submissions. Again, in terms of the main issues, we just go into a little bit more detail there. If we look at the large concerns raised from a religious perspective, was an objection to same-sex marriages, which was something that was already contained in the legislation prior to this, so it wasn't really something that was subject to amendment in the bill, but people are voicing concerns about their original objections to the civil union, which is a separate piece of legislation that is now being integrated, as well as some concern around polyandry, where it calls for equality for both men and women to have multiple spouses, was raised, even though this again in turn was not really the subject of the bill. Then there was a strong call for a recognition of Sharia property law, and that the property default regime should be out of community property. And then conscientious objection was also significant. Up to a quarter of the submissions were speaking about the ability for religious people to object to solemnizing same-sex marriages. Again, this is something that's already contained in the bill. It's just not allowing for Home Affairs officials who have religious inclination to object because their responsibilities to the state in terms of equality. And then lesser but also significant contributions on the considering of more conventional language like husband and wife rather than spouse. And then a call for congregations to be not needing to be as large in order to be registered as a marriage officer. And yeah, so these are the concerns organized in terms of subject matter. So the religious concerns are predominantly those. Then we go into vulnerable groups. So this again, the concern to protect children and also the institution of marriage by raising the age of marriage to 21, the voiding of child marriage, which again is contained within the law, but an emphasis there, and the banning of ukatwala, kind of a forced marriage, which again is protected in general by the law, more on the criminal side of law, but it's implied here. And then gender-based violence vetting for polygamous unions, saying that there needed to be some kind of vetting in addition to the financial, also having some form of vetting to prevent persons with violence taking on additional partners. And then the disability rights in terms of the sound mind clause, the department will go into this in some detail in their presentation. And then the mandatory premarital counseling, from quite a few people will mention that. And then also perhaps more assistance, overt mention of assistance for the divorce process and protecting of extramarital children, particularly in the case of divorce or decease, so that the children are taken care of. And then looking at the cultural and customary preservation, they were called from more traditional religion or traditional practitioners to remove the first wife consent, as this is not in line with some African traditions. Again, the department goes into this in some detail. The lobola being equated with marriage, and so accepting the more informal types of marriage as recognized by the state. Then again, mention of Khoisan and royal recognition of their particular kind of marriages. Then consanguinity, which is essentially between marriage between usually two cousins, and particularly more in the royal lineage, as some inclusion of that, mention of that. Then, yeah, some mention of the traditional courts and their authority to conduct marriages. Then some speaking against polygamy, in the sense that, or in favor of polygamy in the sense that it will allow for the extension of a family line, particularly when the first wife cannot have cannot have children. And then, some concerns around the undermining of the chieftaincy and then their inclusion in reference to the marriage laws. And then in terms of international security, there's a lot of mention of the marriage of convenience and how this is used as an entryway into the formalized documentation within the department. So a calls there for increased vetting, DNA testing, like better enforcement of the 5-year minimum residency requirement, better methods for verifying marital status outside of the country. And as we heard last week, and issues around ID and document theft and ID fraud, increased prison penalties for those conducting fraudulent marriages, as well as those in those marriages, checking into more cross-border enforcement, as mentioned, and yes, then perhaps the tendency for exploiting young, particularly women, for those marriages in terms like in return for financial gain. And then there were a series of more administrative reforms recommended, such as extending the registration period to allow for up to 30 days. And then appointing ward councillors or social workers to broaden the pool of designated marriage officers. And increasing the amnesty window for recognition of historical marriages, particularly like Lobola, as mentioned before, marriages conducted purely in traditional terms. Education in indigenous languages, so more reach out and outreach to those who are not in the majority or the larger language groups, so they understand what's happening in marriage. The sound mind testing to include breathalyzers or the testing of sobriety, and again for a call there for the legal protection of government officials that have religious objections. We then do a provincial overview in terms of the primary issues raised and the sentiment towards each of to the bill from each of the provinces. So in the Eastern Cape, for instance, we have 74% for the bill and 14% against. In contrast to Gauteng, where we have, or the Free State, where we have 37% for and 27 against. Gauteng 22 for and 63 against. KwaZulu-Natal 23 for and 53 against. Limpopo 35 for and 41 against. Mpumalanga 52 and 23. Northwest 47% for and 25% against. Northern Cape 21 for and 67 against. So quite a contrast there in comparison to Eastern Cape, where there was predominantly sentiment in favor. The Western Cape, a balance there actually between those for, against, and partially for, and then a variety of different mixed views across the provinces. Again, we're just highlighting there what the main issues in each of those provinces were. It's the same issues that I mentioned above. They're just organized here by province for ease of reference. However, like for instance, if you look at the Western Cape, for instance, there was a stronger contingent, as is expected in urban areas, of the mention of LGBTQIA plus issues, as well as Khoisan indigenous recognition or rights, as compared to the Eastern Cape, where there's a lot of mention more of the traditional, as also in the Limpopo, of recognition of royal customs and the traditional law. And then we just look at a map of those primarily for and against, just to give a visual idea. This was in the presentation I did before, indicating there that only really one province was predominantly in favor of the bill, and pretty much the large middle of the country more against the bill, and then the north and south indicating a bit more of a balanced or mixed view. We then kind of go into detail as required for the reporting, just of exactly where we visited, how many participants, how many submissions, and the top main causes or top main sentiments in those provinces. For instance, we'll go back to Gauteng because it was quite a while ago, our first public hearing, mentioning that there are concerns between of the conflicts between religious and Christian values and secular values. The same-sex marriage is viewed as un-African or unbiblical. Polyandry viewed as culturally and religiously offensive. The need to protect the nuclear family, and fraudulent marriages of convenience to foreign nationals seeking citizenship. So then we have much of the same for each of the remaining provinces, indicating the number of participants, the number of submissions, and the main concerns in each of those areas. Again, we've highlighted these up above. These are just organized by province, so that there is a kind of a regional cover of the difference in the regional sentiment. Yes, I won't belabor those points, but that's contained in the report, and these issues will be dealt with more under subject rather than under region when the department responds. But yeah, just basically indicating that there was significant participation across the provinces, significant engagement, and a diverse set of views expressed across the provinces. Okay, then we do a clause by clause segment of the analysis, which allows us to hone in more specifically on what it dealt with in the bill. And this is kind of the focus that the department is bringing in their presentation. And in terms of clause 5, the cultural conflict versus in different kinds of shelters now being combined into one piece of legislation. Secondly, the concerns around parents not being able to, or having their young children being married without their consent, and the call there for the increase of age, not because of the children aren't ready, but because the parents don't want to give consent that early. Also calling for harsher penalties, calling for those marrying under. So is there a point of order? Okay, I'll continue. Clause 5.1 are relating to sound mind. So this is both the sound of mind in terms of mental well-being, but also altered states of mind, sobriety, which the department will go into. And then, yeah, clause 5.2 specifically the mention of petty marriage practices, such as marrying the Nangso Yalaba, where if I recall correctly, it's relating to the marrying of the daughter by the brother of the deceased. And then, yeah, 5.4 relates to foreign nationals and the verification challenges and stricter vetting. 6.2 is written consent for polygamy, some calling in favor of it, some saying that it's not in alignment with traditional culture. Secondly, there's a call there for like the return to the traditional terms of husband and wife rather than spouse. 6.3. Chapter 4 relates to the designation of marriage officers and the presence of witnesses for better enforcement of who those witnesses are. So it's not just people from the street. Improve security. A conscientious clause, again, we mentioned that above. The prohibited relationships, such as in terms of people with criminal sexual offences or violent past, as we mentioned before too. And then objection to marriages in terms of clause 12. There's a clear guidelines on what constitutes an authentic objection and when this needs to be raised. So that's then my place. Then the registration window, again, some arguing for a shortening of that period and others requiring a longer period. Shortening in terms of security, so that there's less chance of interference, and longer just in terms of the administrative burden of getting to a home affairs office from more rural areas. And then chapter 6, clauses 15 relates to property after decease or divorce, and particularly concerns on the distribution of assets in customary marriages, which cause some conflict in traditional councils. And also the split between urban and rural, which is mentioned quite a bit, that there are formal marriages in the urban areas that can take precedence over more informal traditional marriages in rural areas, and where they tend to be disadvantaged in divorce proceedings or in deceased estates. And then lastly, in terms of the actual act, offences and penalties, again, they're the call for increasing the fines and making them harsher in some ways as a deterrent. And then in terms of the big written block, but also significant oral submission, the main concern from the Muslim community was that nikah, and like the traditional way of conducting Muslim marriages, should be recognized even prior to solemnization with registration, not needing to have to be administratively registered with the Department of Home Affairs separately. And then secondly, the default property regime, as mentioned, being out of community of property. And then the automatic designation for imams. So they don't want to have a minimum congregation size. As long as you're an imam, you should be able to conduct a marriage. Constitutional and case law compliance. The legal section of Parliament will do a formal response on the legal requirements of the bill, but we do need to mention them here because this limits the extent to which we can actually change the bill in favor of public sentiment. The department will also speak to this in their response. But basically, the Women's Legal Centre case required the better recognition of the Sharia marriages to improve dignity and the interests of the child. So important to remember there that not about the conservation of only about of the Muslim tradition, but also particularly the protection of children in terms of the larger laws of the country. And then also the emphasis of the difference between, or the conflict between the rights of equality, where all persons in the country need to be subject to the same rights of protection, versus the rights to religious freedom, to demand a conscientious objection, for instance, from religious practitioners versus the rights of LGBTQI communities to have civil
Mm.
unions, irrespective of the religious inclinations of the marriage of the officials solemnizing the marriage or the union. Yes, just again, like the emphasis there on the sections of the Constitution that apply, the equal rights in terms of Section 9.1, legislative measures implement to improve equality progressively on 9.2, 9.3 of the Constitution, preventing unfair discrimination against anyone on the grounds of race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. And then Section 10 on measures on here ensuring human dignity. Again, something that was mentioned in the case law and the Women's Legal Center Trust case, and then the constitutional limitation clause is important in that certain rights can be limited, but only if in terms of the law of general application, to the extent that such a limitation is reasonable and justifiable. So this is, can we, for instance, limit religious freedom if it's in the interest of improved equality? And then protection of women and children. This relates to the Mayelani case, and basically that allowing a husband to marry subsequent wives without the first wife's consent is incompatible with the rights to equality and dignity. And then just the mention of the international law, which again the department goes into, or specifying that, like for instance, particularly on the marriage, underage marriage, that the minimum age is internationally set by UN Convention on the Rights of the Child and African Charter on the Rights and Welfare of Children, as well as South Africa's Children's Act, indicating that 18 being the minimum age of consent, not the required age for marriage, but the minimum age. And then essentially just indicating in closing that the legislation is needed to strike delicate balance between rights, as in human rights grounded in the constitutional equality, and a framework for rights, as in more traditional prioritizing of the sanctity of religion and traditional marriage solemnization. And again, then two general sentiments in terms of either keeping the legislation as one piece and amending it, or actually some arguing in favor of keeping the act separate to allow for more specificity in each of the respective pieces of law. I thank you, Chairperson. That's my summary.
Thank you very much, Mr. Adams, for the summary. Members, if you have comments, we'll also move to Department of Home Affairs. I want to check if you have comments. There's two areas which we may need to balance in terms of the strength of argument of submissions made, which must also influence how you tap the percentage that you have outlined. I've gone through the document, and in some of the aspects, in the comparison of the notes, the percentage, they're not tallying with the expressed views which members of the committee have made. So we may need to see how we extract that, so that it must not suggest that certain views were not carried. So in other words, if you build on a scenarios, you ought also to give the reasoning or the foundation in which members of the public or stakeholders are rejecting a particular provision or chapter, and also are supporting. So there must be a balance of the two, so that a percentage may not even assist us to understand or assist to for members of the public when the committee also are engaging now on what are the balance of points in relation to whether this chapter has been supported and what are the areas rejected and what are the areas. So I think you may need to assist us. Let's just take the issue of
It's my comedy and ENC is covering us.
we are disrupting.
So nervous. I'm so nervous. Oh my God.
Honorable Matapo, I'm not sure you.
I have a question based on it.
Honorable Matapo.
With the scientific wisdom and the
member there, I don't know who's. Yeah. For example, if you look at the age for rising from 18 to 21, and I think there's legislation both domestic and also international. So it says 35 rejected the increase of 18 to 21. And you can see that you ought to assist the committee and also members of the public to understand the scenarios and the modalities that were applied to deal with that fact. So I just wanted to make that comment amongst others. Members, Honorable Rose and Honorable Mutapo. Sorry, Mkhale.
Thank you, Chair, and thank you for the preparations with the report. Chair, the first input is really for the very beginning. The report talks about the bill's primary objective being to unify existing marriage laws into a single legislative framework that guarantees equality and dignity for all individuals, irrespective of race, sexual orientation, religion, or culture. Chair, I think I discussed it at length in the last meeting, but I think we really should add gender here. We're here because of the Women's Legal Centre case on how women are affected by the existing legislation. And I think it's very important that we specifically list gender as one of the items in that list over here. Then, Chair, this is a report on what the public said. So I can imagine there's some sort of aggregation, and you can then produce some sort of outcomes. As you pointed out, some of the percentages might need to be looked at. But I want to repeat my concern from the last time when we saw the PowerPoint, where the report talks about written submissions drastically altering the national mandate. And this wording, Chair, it gives the suggestion that the oral submissions are the national mandate, and then the written submissions skew it, and that the overall figure may not be a true reflection of sentiment. I don't know if it's just me, Chair, but I don't know if it's necessary in a report like this to make a statement like that, because whether you have a oral submission or a written submission, it is a submission. There's no order of the weighting and importance of submissions. So, for example, if written submissions were not allowed, who's to say then those writers would not have come out and given oral inputs? So I think we need to be very careful when we say that they skew the results, because whether it's oral or written, they all come together into a pot. And to give a counterexample, I mean, there's no explanation of why the oral testimony is the way it is. It could be affected by the fact that communities are in front of political leaders, or they're in front of community leaders, or their traditional leaders sitting there, and it could influence how they respond. So I think we need to be just very careful about making that statement that the written submissions were orchestrated, and they skewed the results. So, Chair, my proposal would be just to take out that thing about it skewing the results. It's the numbers are there and they as it is, and people must interpret it as they see it. Then, Chair, the final issue is on the typology, and just again to just ask that the report gets a fine looking over again, especially page 15. There's some typos like Concord. Precedent is capitalized. Parliament is in small letters, even though Parliament is a institution or a noun. So also just to look at the typology to make sure that the report is has professional typology throughout. But Chair, that's it from my side. Thank you.
Thank you very much, Honorable Ross. Honorable Mokhale.
No, thank you very much, Chairperson. I think Honorable Ross has touched on some of the things that I wanted to deal with because we're not doing a memo, what you call a referendum here. It's not a referendum. We're in the process of drafting legislation. So the views as they come, Chair, it is our duty as Parliament as the committee to process all those views in line with the Constitution of the Republic. So we need to be clear on that one. Chairperson, I saw something on the report which I'm not clear, and I would like the content advisor to tell us where that came from. There's a section there, I think it's 5.1 of the report there. I don't know if we could put it here, but it's okay. It speaks about marriage in the tummy. Where did we encounter that idea? Because I don't remember anywhere in the provinces that we've been to something like that was raised. A marriage in the tummy. So he needs to explain to us what is that, because we have never seen that thing. We've never encountered that. Thank you, Chair.
Any other member comments? Okay, thank you. Mr. Adams?
Thank you, Chair. Let me just respond to the last one first, because that was a direct one. This was feedback that we got from the public education unit in their engagement in the public education issue. They said these are some issues that came up in the public education that weren't raised formally in the marriage hearings, because maybe some people weren't able to attend. That's something culture. I mean, we may or may not include it. It's reference to something that emerged in those community consultations prior to people coming to the actual public hearings. So I can leave it to the members if they want to exclude that. But that was also there was mention of that in one of the written in one or two of the written submissions too. So we obviously provide us an overall summary, but we're not making reference to individual applications. So there's maybe some of that detail lost. Yes, I take the points from Honourable Roos on the rectifying those minor points in terms of the language, and in terms of the percentage. Yeah, I think I can put in a qualifying statement to indicate that the percentage is just an overall ability to capture an overall view. It doesn't necessarily capture the fine nuances of what happened in informal settings. And I can also qualify some in reference to the age and gender. I think what the chairperson indicated at the beginning of the meeting is that we'll incorporate the response of the department into our report, and that will give perhaps a more comprehensive overview of those fine legal issues, if I understood correctly, chairperson.
No, I don't think that you understood correctly what we're trying to. Let me start with this one of Honorable Mokhale. I fully agree with Honorable Ross in terms of the issues that he has raised that relates to the report. And I think the principle that we have reference when dealing with the public hearings reports, as you present them at some of the areas, they distort completely what we're receiving from members of public on some of the issues that we have presented. And I think the committee does not suggest that the entire report is flawed, but we suggest that this report is drafted by the research team. We must add and correct some of the issues that must empower us as the committee, but also when we raise issues with the department, at least the department understand where is the report that has been engaged by members of the public. And I'm sure the last matter that Honorable Mokhala has raised, we have not interacted with in all the public hearings. And if you put in this space, you must know that it's not the committee that are interacting with the report. It's members of the public. And some section in our communities, they may feel offended on some of the description that Parliament articulate the position that they've engaged with the committee. So we may need to be, you may need to be alive to these issues. So you are unable also to explain to the committee how you frame that. So we'll suggest that we'll interface with the matter when we empower it with the with the public education unit. The research team that has, and I assume that all of you have able to consolidate this report, including the modalities that I've indicated on the percentage that they've arrived at. Let's note those issues, members. And as I've said earlier on, I've went through the report. That's why I've cautioned the committee that we may not consider to adopt it given the issues that you have raised and some of the issues that we may need to engage the report. We will not consolidate a report of the Home Affairs and the report we have received. What we will consolidate is the report from members of the public, and the department must respond to the reports, the issues that have arrived from members of the public. Once that has been done, we engage with the department. Therefore, we deliberate on the issues and we adopt the report that we must submit to the House. Can I now invite Deputy Minister to introduce the report on the DG? And then members will also interact with the report.
Yeah, no, thank you very much, Chair. With me, I have the DG as well as DDG Mavuso and DDG from Civic Services, and then Mr. Malakate, who is from our Legal Services. I will not waste a lot of time, Chair, except to indicate, firstly, that we have gone through the report that you had given us and congratulate the committee on the consultations that they have done. We have taken those into considerations and we have prepared a presentation to make reflections on how we think some of them should be handled. We go through each grouping of the submissions that we made. I will then, through DG and through yourself, Chair, allow DG and Advocate Malakate to then take you through the detailed presentation on the matter. And also, Chair, on the apologies, I see that we did not receive any, but the Minister did apologize. He had some other engagements to go and deal with. That is why we are then here to continue with the work. Thank you very much, Chair.
Thank you, TM. DG.
Good morning, Chairperson. Morning, honorable members. Morning, DM. Advocate Malakat will take the committee through the responses as requested. Thank you, Chair.
Thank you, DG. Advocate Malakat.
Good morning, Chair, and good morning to honorable members of the committee. Good morning to the Deputy Minister of the Department of Home Affairs, as well as the Director General of the Department, and good morning also to the Deputy Director Generals of the Department of Home Affairs who are present in this meeting. Chair, I think the Deputy Minister has dealt with our introductory part, and just to indicate that the department was part of the public hearings that was held all through the Republic of South Africa. That during those public hearings, we listened to the oral submissions at each and every session where during the public hearings, you would recall that there were also other matters that we then at that point in time were able to assist the public by clarifying the intention of the clauses and the what is then required to be dealt with. So, Chair, when we just want to go, Mozi, if we can go to slide number 6, just to indicate that from these slides, we are just reflecting on what we had already done in the development of this bill, and reminding the portfolio committee that this bill was introduced around December 2023, that the department has then provided a briefing to the committee on the contents of the bill and the intention of the bill. The Office of the Chief State Law Advisor also made a presentation before the committee and provided the reasons why they had provided a qualified certification opinion. Also, just to remind the committee that the Parliamentary Legal Services had also made a presentation on the bill. In the next slide, again, we just reiterating the flow of what then happened thereafter. You would recall that the bill was then published for public comments, public participation from the committee side, and there were written comments that were received by the committee and also provided to the department as well as Oxley and Parliamentary Legal Services. We just wanted to remind the committee that then the committee had then resolved to engage in the public hearings across the Republic, which had been done between November and February 2026, and we have been part of these hearings. And we just reflecting again that on the 3rd of March, the content advisor presented a public hearings report, and that the committee had then resolved that the content advisor would need to have a relook at it and submit a final report, which he then we confirmed that he had then presented and provided to the department. And earlier this morning, the content advisor had then also spoken to that report. Chair, in the next slide, we just indicating the responses from the department and how we have structured our presentation. We first deal with the oral submission that impacts on the clauses and deal with those, and then we'll then at a later stage then deal with other matters that are not dealt with in the bill, but we reflect on them and provide the department's responses. So when we go to the next slide, Chair, that is when we start beginning to deal with the salient issues that came out from the oral submissions during the public hearings. And critically, under clause 5, there were 2 issues that we were able to pick up, which even the report from the content advisor also picks up. This relates to the age limitation, and as well as what is meant or understood to as being of sound mind. So with the age, you would recall that many of the participants during the public hearings, some were indicating that the age set at 18, those children are still immature, that some had made a presentation and submission to say that perhaps we may consider increasing the age from 18 to 21, some were saying 25, some were saying 35. But we, as we did during the public hearings, and as we are going to do today, is just to remind the committee that the age limit that has been set in the bill, it's in line with section 28.3 of the Constitution. And section 28.3 of the Constitution defines a child as any person under the age of 18. We then also reflect on what the Children's Act says as it relates to the definition of a child, and it reiterates what section 28.3 indicates, that a child is defined as any person who's under the age of 18. So from age 18 and above, that individual is then regarded as an adult. Then we submit to the committee that there are other international instruments that we have looked at, and that the age limit that we have provided, that we have set, it's in congruence with these international instruments. Off the bat, we remind the committee that in terms of the Sustainable Development Goals, the UN member states have committed themselves to eliminate child marriages by 2030. The African Union campaign to end child marriages, which was launched in 2014, mandates that member states define a child as anyone under the age of 18 and set the minimum marriage age at 18, and to enforce registration of marriages. It is therefore a legally binding framework aimed at ending the harmful practices and ensuring girls' education and protecting human rights. Article 21(2) of the African Charter on the Rights and Welfare of the Child states that child marriages and the betrothal of girls and boys shall be prohibited, and effective action, including legislation, shall be taken to specify the minimum age of marriage to be 18 years and to make registration of all marriages in an official registry compulsory. Again, re-emphasizing the fact that the age of 18 that we have said is in congruence with this international instrument. In the next slide, Chair, we are dealing with Article 16(2) of the Convention on the Elimination of All Forms of Discrimination Against Women, which states that the betrothal and marriage of a child shall have no legal effect, and all necessary action, including legislation, shall be taken to specify a minimum age for marriage and to make the registration of marriages in an official registry compulsory. Article 6B of the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa obligates state parties to ensure that women and men enjoy equal rights and are regarded as equal partners in a marriage. It goes further to say that state parties shall enact appropriate national legislative measures to guarantee that, and to set the minimum age of marriage for all women at the age of 18. Again, just to re-emphasize the fact that the age of 18 is also in congruence with the international instruments and international obligations that South Africa is signatory to. So the department is therefore of the considered view that Clause 5 1A of the draft bill, it's in line with the provisions of Section 28.3 as well as the Children's Act, but also in line with the international instruments that prohibit child marriages. So the requirement only sets the minimum age limit for marriage and should not be interpreted to obligate anyone who is 18 years to enter into a marriage. Those who are 18 years and above and who elect to conclude or to participate in a marriage will be allowed to do so. So in effect, it simply allows or creates an opportunity for those who are 18 years and above and they elect to conclude a marriage that they would be able to conclude a marriage. It is not mandatory that a person, when they turn 18, they should get married. In the next slide, Chair, we trying to so that for purposes of the committees, of the members of the committee to understand what we mean, but just to provide an understanding of what is meant by a sound mind. So sound mind refers to a person's legal capacity, memory, and understanding which is sufficient to comprehend the nature, purpose, and effect of their actions, such as signing a contract or making a will. It signifies that an individual is mentally competent and is not suffering from any impairment or intoxication that prevents rational decision making at that specific time. So sound mind, it's looking at how the person is at that particular point in time when a contract is being concluded. And just to reiterate that a marriage is regarded as a contract. Then we further provide case law where our courts have dealt with what is meant by sound mind. And in SMW versus JJW, acting judge Njokweni in paragraph 16 had then indicated that in terms of our common law, the general principle is that if a person is not able to fully understand or interpret all the consequences of his action due to a mental illness or intellectual disability, it is said that such a person lacks capacity to perform a specific act, and the act that has been performed will therefore be consequentially void. And then they go further to deal with what was before the court at that point in time relating to appointment of curatorship. In the next slide, we then provide another case law where the High Court or the court had then indicated what is then termed to be of sound mind. And we just want to zoom into the underlined area and indicate that the court had then said whether his mind, the question is whether his mind was such that he could understand and appreciate the transaction into which he purported to enter. So therefore, it is an inquiry into the condition of a man's mind in a very difficult and delicate inquiry of which both parties to the litigation are entitled to due notice. And the court then goes further to deal with the requirement of an intention, which is animus, and they say an intention is not an essential element in relation to contractual obligation, but we are looking at whether or not the person at that particular point in time possessed the necessary intelligence, which would then allow the person to take a decision at that point in time. Chair, you will recall that during in the next slide, that during the public hearings, we had then indicated and responded to what we meant by sound mind, and we had also indicated that the department will, before a person is designated as a marriage officer, conduct training to all prospective marriage officers. And during this training, the concept of what is meant by sound mind will be further explained. Further than that, the regulations may be made to further explain the concept, just to ensure that marriage officers understand what is meant by sound mind. And we just reiterate that the test that is used, it's objective and looks at the circumstances at the time the marriage it's solemnized. In the next slide, Chair, we are dealing with clause 6. And you would recall, and the content advisor also spoke to this. The consent relates, which we were able to deduce, relate to clause 6, subclause 2, paragraph A of the draft bill, which clause requires written consent from the first wife, or in the event where there is more than one wife, from the wives. The consents were mostly in instances where the first wife or wives would have withheld such written consent. And we responded, and we still respond, Chair, and submit that the husband is not without remedies. The husband has remedies, and he may approach a competent court for a declaratory order to dispense with such a consent. Those are the remedies that are available for him. The second submission related to clause 6, subclause 3, and also the content advisor had alluded to this, and this is in relation to the definition of husband, which appears there. We also need to submit, Chair, that the use of the terminology husband and wife only appears under this clause and nowhere else. And this is the intention is to be clear that we deal with the unintended consequences had we not defined what a husband is in this clause. And this clause is dealing with polygamous marriages. So we, in response, the department wishes to submit that polygamy by its nature is grounded either on religion or on culture. And we are of the considered view that the perceived discrimination is actually in line with constitutional principles as it serves a government purpose, and we are of the view that it is rational. And we further go and indicate that in our view it meets the requirements stipulated under Section 36 of the Constitution and is therefore fair. Chair, this terminology is used in order to deal with instances where we may inadvertently, if we did not define what is meant by husband, where we may inadvertently introduce elements of polyandry, which you would recall during the public hearings. Many of those who made or who made oral submissions were totally against the introduction of polyandry, and in fact we had then clarified also that polyandry is not part of this bill. So if we do not define husband, we may inadvertently introduce polyandry. But also, just to ensure that, Chair, the right to culture and the right to religion, as it is embedded in and entrenched in Section 15 of the Constitution, the state, although it is obligated to ensure that it respects and protects culture, that we do not at this level encroach on that right, and therefore we will only accede to what culture defines and what culture then takes as polygamous marriages. Hence we have made the definition and the distinction as it is. In the next slide, Chair, we're dealing with solemnization of marriages, and we are here the submission was that the draft bill must ensure that religious marriage officers are not compelled to solemnize marriages involving same-sex couples, and secondly that there was a view that the draft bill forces public servants to act contrary to their religious belief and does not allow them to opt out of solemnizing same-sex marriages. There are two responses that we then provide, Chair and members of the committee, that under clause 11.4, it is clear that marriage officers, other than those who are public servants, who are ex officio marriage officers, they are not compelled to solemnize marriages against their conscience and religion or belief. In fact, the clause that deals or that empowers the minister to designate marriage officers has been it creates a larger pool, and it allows for the minister to designate those who hold certain positions within the four areas that have been tabulated there to designate them as marriage officers. And we believe that then takes care of this perceived idea that those who are religious marriage officers will be compelled to solemnize marriages that involve same-sex couples. However, when it comes to public servants, Chair, we submit that as a public servant is required to follow the Batupili principles and cannot therefore discriminate when providing public services. And we are therefore of the view that such an option to opt out from solemnizing marriages of same-sex couples should not be made available to public servants because of the Batupili principles, as well as the obligations that flow from Section 7 of the Constitution in terms of the state protecting, fulfilling, and making sure that the rights that are contained in the Bill of Rights are fully enjoyed by those. In the next slide, Chair, we just want to remind the committee that in 2020, there was a private members' bill where in the opt-out, Section 6 of the then Civil Union of 2006, had allowed for public servants to write to the Minister of Home Affairs and to indicate to the Minister of Home Affairs that they would want to opt out of solemnizing marriages of same sex. And the Civil Union Amendment Act took that away, and currently all public servants are required by law to provide the services. And we just reminding the committee that the Honorable Carter, MP, in summation, it then says, in the context of South African same-sex partnerships, many same-sex couples may be obliged to have their marriage conducted by civil servants because the religious bodies they attend are unwilling to do so. The prevalence of homophobia in our society could mean that a large number of civil servants will avail themselves of the statutory right to lodge objections, resulting in same-sex marriages becoming available in theory only, especially in rural areas. This would clearly constitute undue hardship for same-sex couples. Honorable Carter had then, before the promulgation of the Civil Union Amendment Act, and then argued that this therefore leads to a conclusion that Section 6 of the Act limits the right of same-sex partners to enter into a civil union, and this limitation cannot be justified in an open and democratic society. And then we reiterate that the power to opt out to solemnize marriages of same sex had then been taken away from civil servants. And in our view, we believe that this should remain. In clause 12, The submissions relate to clear guidelines on what constitutes authentic objections and when such objection must be raised. We submit, Chair, that Clause 12.1 of the draft bill is very clear and it provides the necessary guidelines when properly read and understood. And if we're to look at the clause itself, it tells us that the objection may either be in writing and orally, and it's also depending on the circumstances of the case, and that such an objection must be made before the marriage is solemnized, and that objection must be lodged with the marriage officer, and that the marriage officer then bears the obligation to investigate the veracity of such an objection. And if he or she find that the objection is credible, he or she will then not proceed to solemnize the marriage as requested by the prospective spouses. And we further wish to submit, Chair and honorable members, that the training will also provide, that will be provided to marriage officers will further substantiate the processes that marriage officers will need to follow in investigating any objection that may have been raised with them. In the next slide, Chair, we are dealing with clause 17, which deals with offences and penalties. And you will recall that during the oral submission, as well as the written submission, Chair, they centered around subclauses 1 up to 7, wherein the submissions are that those provisions must explicitly specify the amount so that will then ensure transparency and to serve as a strong deterrent. What we have done, and if you were to look at the clause, we have left the determination of the fine to the presiding officer or the judge or a magistrate, and we have done so given the fact that in South Africa there is a minimum sentencing act which then allows or provide guidelines, sentencing guidelines to presiding officers, and we believe that should be left at that, and this would be in line with the principle of separation of powers. So in this regard, Chair, we wish to submit that this bill does not necessarily need to specify the amount, that it should be left to the minimum sentencing act, and that the courts would then look at the fine in relation to the number of years that have been provided as the years of imprisonment after conviction. In the next slide, Chair, we then deal with issues that have not been, or that does not impact on the clauses themselves, but that came out from the oral submissions that we found, and it is also in line with the report that has been provided by the content advisor. So we have followed the thematic areas that the content advisor had then extrapolated from the report. So there were religious and cultural concerns, and one of the submissions was that many had objected to the introduction of a unitary legislation, and had then advocated for the retention of the status quo, and requested that the department must draft a bill simply to recognize Muslim marriages. This submission was around mostly the inclusion of same-sex marriages in the draft bill. So most of those who made their oral submission were indicating that the current marriage legislation should remain intact, and that what we simply need to do is to deal with the recognition of Muslim marriages. However, given that the white paper that has been approved by Cabinet advocates for a unitary legislation to deal with marriage. We are of the considered view that this is in line, and when we come to the inclusion of same-sex marriages, Chair, we are reminded as the state of the obligation that is enjoined on the state, and of the bat we are reminded of the supremacy of the law as it is contained in Section 2 of the Constitution. But primarily that Section 7.2 of the Constitution enjoins the state to respect, protect, promote, and fulfill the rights that are contained in the Bill of Rights. Further, that Section 9 further enjoins the state to ensure that it does not unfairly discriminate either directly or indirectly against anyone on the grounds that are listed under the. So the department therefore cannot exclude same-sex marriages from the draft bill, as the draft bill seeks to rationalize and recognize all marriages, irrespective of whether or not they were entered into following the tenets of a particular religion, or following the tenets of a particular culture, or following the tenets of a particular belief. So, Chair, we believe that where we are, that the bill is sound in law, that it complies with the Constitution, and it allows for everybody who wishes to enter into a marriage that they would be able to do so, and that their marriages will then be recognized, and the department, upon registration, would then be able to issue marriage certificates to those whose marriages have been registered with the department. In the next slide, Chair, we then zoom into some of the marriages that we were made alive to during the oral submission. In fact, it became crystal clear when we were in Groblersdal in Tafelkop that there were certain submissions that were indicating that there are other types of customary marriages that in terms of custom are recognized, and the example that were given in Tafelkop was Timamolo Mwechialapa, Siantlu, and issues related to Ukungen. So, Chair, we believe and we wish to reiterate and submit that we are of the considered view that the bill should not deal with each and every aspect, cultural practices within each and every religion, custom, or belief that is within South Africa. We submit that the aims of the bill is to ensure that all marriages, irrespective of the religion, irrespective of custom, irrespective of belief, should be recognized and registered. And the bill does not seek, in our view, and we submit, to regulate religion, culture, or belief, as this does not fall within the competence and the mandate of the department. So in our view, whether or not such customary practices should be recognized, we believe falls outside of the mandate of the department, and perhaps it would be those issues that the Department of Arts and Sports and Culture, or the Department of Cooperative Governance and Traditional Affairs may be seized with in terms of how we need to deal with. For our purposes, we then submit, Chair, that for as long as a marriage is recognized as a marriage in terms of each religion or each custom and belief, we believe that the department will then bear the responsibility to ensure that such marriages are recognized and a marriage certificate is issued to prospective spouses. And we submit that, Chair, it may be a very tedious and cumbersome legislation if this legislation were to then attempt to deal with all the cultural practices that are within the Republic. The other issue that was submitted in relation to religious and cultural consent, it states that the draft bill in some of the submitters should not deal with the consequences of customary marriages. In fact, it is then argued that the Women's Legal Trust Center judgment does not obligate or did not order Parliament together with the President and the Minister of Home Affairs and the Minister of Justice to deal with the consequences of marriage. So basically the argument is that the legislation should only deal with the recognition of Muslim marriages and not deal with the consequences of such marriages. Chair, we wish to remind the members of the Portfolio Committee that in fact the judgment itself, when properly read and understood, does order the President, the Minister of Home Affairs, the Minister of Justice, and the Department to not only come up with legislation or amend the current legislation to recognize Muslim marriages, but also to regulate the consequences of such a recognition. So we are here in this slide spelling out what the order was in itself and reiterating that indeed the Constitutional Court ordered that we needed to deal with we needed to regulate the consequences arising from the recognition of Muslim marriages. So basically, once you have entered into a marriage, what would be the consequences of such a marriage? And we are dealing with that in the bill. And therefore, it follows that the department has fully responded to the order as we are quoting above. Chair, in the next slide, we deal with a submission from the Muslim community, and the submissions are threefold as we could deduce. One is that the draft bill seems to be not in tandem with the right to religion as it is encapsulated under Section 15, in that under Sharia law, we are told that a girl may be eligible to conclude a marriage at the age of 16, and therefore the age limitation that is set at 18 encroaches on this right. It is further submitted that Muslim marriages must be automatically out of community of property and profit and loss, that there should not be any default matrimonial property regime. And the last submission is that in terms of Sharia law, the presence of prospective spouses during the solemnization of the marriage, in particular when it relates to a woman, that is not allowed. So we, in our response, Chair, we indicate that, well, in terms of the Constitution, and in particular, Section 15, subsection 3, paragraph B, reminds us that whenever a person practices his religion or culture, he or she must do so in a manner that is consistent with the section itself, but also other provisions of the Constitution, and therefore anything that is done must be done in line with the constitutional principles and values. And in our submission, Chair, we submit, honorable members, that the age limit that has been set in the draft bill is consistent, which is 18 years. This is consistent with the Constitution, as we had indicated previously, that in fact Section 28(3) of the Constitution defines what a child is. Similarly, Section 1 of the Children's Act defines that, and that in fact we bear the obligation to ensure that we set the minimum age limit in terms of entering into a marriage at the age of 18. So we are of the considered view that we are correct in setting this age limit. So the other in response in the next slide will deal with the other submission, and we want to indicate and we submit honorable members that if you look at the current bill, there is no default matrimonial property regime. In fact, those prospective spouses are free to choose the matrimonial property regime that will be applicable to their marriage. And this is in line with the principles that are found in contract law and which simply indicates that parties are free to define their own terms and conditions of their contract, of course subject to legal limitations. And we believe and we submit, Chair, that the bill as in its current form does not force any prospective spouses to enter into marriages of community of property, but that they are free to elect the matrimonial property regime that is applicable to them. When it comes to the presence of prospective spouses during solemnization, we simply want to indicate and submit that this is to ensure that spouses, of course, have given their, they have consented to the marriage and that they have consented to the type of marriage that they want to enter. And how else would the marriage officer determine that the consent has been granted, if not requesting whether or not such consent has been granted during the solemnization of the marriage? And if that is not stipulated in this bill, we believe that it may create some form of unintended consequences. And we submit that, the religious and cultural practices are and should be left to the religion or culture itself to deal with. In the next slide, Chair, we again still dealing with a submission that it became very clear in Tafelkop, Chair, where there was a submission, Chair, that seeks to indicate that there are customary practices in terms of which it allows for cousins to marry each other as well as other relatives to marry each other. We just want to reiterate that we have noted that, but that the aim of the draft bill is not to regulate religious or cultural practices, and that should be left with that. But we want to submit to this committee that in terms of our current law, there is already prohibitions as it relates to incestuous relationships. And if you were to look, by way of an example, if you go to Section 12 of the Criminal Law, the Sexual Offences and Related Matters Amendment Act of 2007, it then tells you that the following persons may not lawfully marry each other on account of consanguinity, affinity, or an adaptive relationship, and who unlawfully and intentionally engage in an act of sexual penetration with each other or sexual violence with each other. They are then regarded as having committed an offense, and they are therefore guilty of incest, and then the prosecution would then follow, and on conviction there will be a minimum sentence attached to that. So we're just indicating that in fact in our law this matter seems to have been settled, and that the Criminal Law Amendment Act of 2007 already deals with it, with this area. In the next slide, Chair, we are dealing with an issue that became very prominent throughout the Republic of South Africa as we were conducting the public hearings. And the submission is primarily that the department should be able to deal with transactional or fraudulent marriages as well as marriages of convenience. transactional marriages are those that people would have entered into a marriage simply for the exchange of money, so that the foreigner will then be able to access the status, the immigration status, by virtue of having been married into those to citizens. So the submission has always been that the department must deal harshly with these fraudulent marriages, and in our response, we respond in twofold. Firstly, that in fact, when we look at the draft bill itself, there's already a provision that deals with issues related to transactional marriages, fraudulent marriages, and marriages of convenience. But that the issue is more on enforcement, and that the department would then need to ensure that there is proper enforcement, and that there is, as well as prosecution where there has been contravention of the laws, and that, of course, in order to deal with this area, we would need it requires a whole of government approach, as some of the issues may have been detected or may be detected by other organs of state, and we submit as such. In the next slide, Chair, it is just some of the issues that also the report presented by the content advisor also deals with this. Is that one of the issues that comes up from these administrative reforms? There's been a submission that seeks to indicate that the period that has been stipulated to allow for marriage officers to submit the marriage register in order to register the marriages is set at 14 days, that it must be increased to 30 days. Some have also argued that the current period that is available should be retained, and that period is 5 days. The current Marriage Act and other pieces of legislation dealing with marriages say requires that all marriages must be registered. And in terms of the Marriage Act, 5 days from the date of solemnization. In terms of the Recognition of Customary Marriages Act, 30 days from the date of recognition. So we believe and we submit that the 14 days is reasonable, and it is sufficient, and it allows for either the marriage officers to come forth and to register the marriages that they've solemnized, but also prospective spouses, should they wish to do so, that they would be able to do so within that 14 days. The other submission was that we need to designate ward councillors as well as social workers as marriage officers. And we believe that, Chair and honorable members, that there may be a risk associated with designating ward councillors as marriage officers. That appointment, we submit, it's a political appointment, and in our view, or we think that it is not permanent in nature, and it may ultimately affect the designation of such an individual as a marriage officer. And if a person who is a ward councillor is designated as a marriage officer and is removed, what then should happen? So we submit that there is a risk associated with such an appointment, and that if there is a view from the committee, we will then leave it for the committee to decide whether or not to include ward councillors and social workers. Social workers, we are of the considered view, and we submit that social workers, by their very nature, they are appointed to deal with matters that has nothing to do with solemnization of marriages, and therefore they should not be appointed or designated as marriage officers, and we should not increase their scope. to that. So, Chair, in closing, we want to recommend to this committee, to the committee, to take note of the department's responses to the report of from the public hearings, as well as the observations that we have made when we formed part of the public hearings and the issues that came out of the public hearings as we understood them. And we wish to reiterate that we are still available and we will assist the committee in the further processing of this bill. Thank you, Chair.
Thank you very much, Advocate Malekate, and the DG for the presentations. Members, this is a presentation or response on the issues that the draft report has highlighted, and also the issues that have raised by the content advisor. There's an area where I also wanted to get a recourse from the department on page 24 that reside with the Department of COCTA, which you have refer that is their responsibility to make sure that they deal with that area of cultural issues, particularly those that have been raised by our public hearings in part of KwaZulu-Natal and part of Limpopo specifically. They may have been raised from other areas of the public hearing, but I think the report also highlight key examples. What then does it mean to how are we going to interface with that, or the department on their drafting? Do you anticipate to engage with the department of COCTA, or you will get a guidance from the committee in relation to this subject matter, so that all of us, it must not get out of hand as relate with that. The second point which the public raised sufficiently is that on the issue of the apostille letters, what are the mechanism that would be in place to make sure that the test of the legitimacy of the person from the origin of the country of origin is indeed legitimate, given that as all of us are aware now that it's possible to circulate a fraudulent document. And I think we now have evidence, given the report that has been presented to the committee. What are the methods that are going to be put in place? It may be difficult, but now that you yourself as a department have a practical experience on the document that have been issued by some within our system and outside, what are the mechanisms that will employ from the other country in relation to this subject matter? I'm also in particular wanted to get a sense from the balance of the methods that have been developed by our content advisor in relation to the percentage that have been raised. I wanted to get a sense from the department. What is your reading? Whether it may not weaken, either strengthen the processing of the bill by the committee is an important area which we need to labor on. The page 23, you indicate that there are certain issues that are cultural and the department may not go into detail with them because the bill may be cumbersome. It may be a complicated statement given that there may be other issues that are constitutionally those that have been raised by members of the public are within the framework of the Constitution. How do you balance that which so that you don't have conflict with the views that have been expressly and legitimate that we may need to engage with as members of the committee? I wanted to ask you to tap in that phrase without marginalizing what you have highlighted as an issue that we may need to deal with within the Constitution. Members, is there any other comment on these matters? Honorable Ross.
Thank you, Chair. Just a few brief things. Firstly, Chair, on clause 6.2a, the consent of the first wives, the department submits that the husband should be able to approach a competent court for a declaratory order to dispense with the consent of the first wife. So my question is, on the background of the Mailani ruling, on the precedents that it's set, it appears that we don't have a discretion here. So if the DHA could explain how it envisages a court would override the Concord ruling of Mailani to dispense with such consent. Then secondly, Chair, we have the definition of polygamous marriage in the bill, which means a marriage in which a male spouse has more than one wife at the same time in terms of custom or religion. It's mentioned in your notes here, that when we look at polygamy and that it should specifically be a religious or cultural construct. Do we need to state this more clearly elsewhere in the bill? My main reason for asking this is that there's been some mentions of saying if you allow polygamy, you should allow polyandry or polyamory. Then you can allow 2 men to marry 3 women or various multiples, etc. And those kind of marriages wouldn't really be in terms of religious or cultural constructs, that we've come from. So if we can just get guidance on that in terms of, is it sufficient just to say we have a definition in the bill that says that when we talk about polyamory, or we're talking about polygamy, and that means a male spouse and more than one wife. That's it for me, Chair. Thank you.
Thank you very much, Honorable Ross. Honorable Machi.
Thank you very much, Chairperson. Firstly, I've got to thank the officials led by our Honorable DM for this formulated report. Definitely, it was not an easy exercise. I've got some questions. In other ones, the Chairperson has covered me. One, the department maintains that the 14-day registration period is sufficient. What empirical evidence or data supports this position, particularly in rural areas where access to Home Affairs offices may be limited? The other one is that the department notes that fraudulent marriages require a whole of government approach. What specific interdepartmental coordination mechanisms are currently in place to detect, investigate, and prosecute such offenses effectively? Number 3, since objections can be made orally or in writing before solemnization, how will the department prevent abuse of this provision, such as multitudinous or frivolous objections aimed at delaying marriages. The last one, the department stated that the public servants cannot opt out of solemnizing same-sex marriages. What protections are in place to manage potential conflicts between public servants' personal beliefs and their constitutional obligations? I thank you, Chairperson.
Thank you, Honorable Machi. Honorable Ngobeni.
Thank you, Chair, and good morning to all of the colleagues. I think firstly, to acknowledge and also to note and also commend the work that has been done with regards to this bill. I think that's good progress has been made. I have maybe one or two observations and maybe points of clarity that I want to ask. The first one is Advocate Malikate spoke about in his report that there must be a way in which the department will be able to have some kind of recourse with regards to fraudulent entering into marriage. In this one, of course, we speak about what has come out in terms of people being able to transact in this fashion. If in fact there is no way of detecting this, how will we prove that? I just want to get a sense as to what mechanisms would be available for us to be able to go after those who transact in marriage or with marriage and also with our citizenship in this way. I'm not sure how that will happen. If you can just clarify that. The second one has to do with the recommendation with regards to ward councillors. I would tend to agree with the submission that ward councillors, in all fairness, it will be difficult for ward councillors unless if they apply in their own state to become marriage councillors, but not simply by virtue of themselves being ward councillors. I think that we would agree with that particular assertion. And also, what is pleasing with the report is the assertion by the bill that it's not trying to regulate cultural practices and also religious practices. We fully agree with that should not be the case, and that should not be regulated or over-regulated. And so what has been the response by and large in terms of the spirit of the bill in different communities as an aggregate perception of the bill? I wasn't in all of the public hearings. I just want to get a sense of that. But other than that, we want to commend the work that has already been done. Thank you.
Thank you very much, Honorable Ngobeni. I will invite Advocate Malikate and after the DG, or if you want to delegate to DDG Mavuso. Advocate Malikate.
No, thank you, Chair. And let me also thank the honourable members for the questions that have been raised. Chair, I think we as it relates to slide 24, where we were talking about the recognition of customary or religious practices, and we say that these issues may need to be dealt with either by the Department of Cooperative Governance and Traditional Affairs, or alternatively the Department of Sports, Arts and Culture. I think we will take guidance from the portfolio committee as to whether or not the two departments or either of the departments would need to make a presentation before the portfolio committee on how best we would need to deal with. But in our view, we still submit, Chair, that this bill should not attempt to go and deal with cultural practices, because, Chair, as diversified as South Africa is, for us to go and deal with the aspects or each and every aspect of cultural practices that recognizes a particular practice as a marriage, it may be very difficult for both ourselves as the policy developers, but also yourselves as the legislature in terms of incorporating each and everything. And we believe that if there is a need for those two departments to come and make a submission or reflections on the bill, we will be guided by the portfolio committee on that. Chair, what we are currently dealing with and what we do in terms of apostolate, in terms of confirming the authenticity of the apostolate letters, is that we liaise with the. So firstly, Chair, let me start by indicating that these are letters that are not issued by an individual, but they are issued by the authorities of the country of origin. So it's an apostolate letter that is issued by the country where the foreigner is coming from, and not from any other person except the authorities. So what we normally do is that we request through our Department of International Relations and Cooperations the samples of these apostolate letters, so that we have a compendium or a list of all of them, and we are also able to verify them through the embassies of the representative countries within the Republic of South Africa. So it's about the authentication, it's about how we connect with the countries of origin, but in terms of what we have as samples of the apostolate letters, and if what we then receive appears to be fraudulent, we can then authenticate same, and if it is found that indeed it is fraudulent, then we will be able to deal with that. Chair, when it comes to the percentage, our view as a department, Chair, and having been part of the public hearings throughout the Republic, we did not get a sense that there was a submission, or the public are totally against the bill as it is. In fact, we got a sense that everywhere where we went, the public was in support of the bill, and of course they would have raised certain issues relating to the bill. But in the main, we did not get a sense that the public was against the bill as it is. The submissions that were made during those public hearings would merely be relating to what we have indicated in our presentation today, and we believe that we have sufficiently responded to that. Even during the public hearings, we were able to clarify all the areas that then came out from the oral submission during the public hearing. But we did not get a sense that there is a majority of individuals from the public who were indicating that the bill as it is, we should not proceed with it. In fact, we got a sense that we needed to proceed with it in order to ensure that marriages, irrespective of the religion, irrespective of the culture, that anyone should be able to register their marriages, but to be able to be issued with a marriage certificate. Chair, we again, Chair, that wish to submit and remind the committee that the Department of Home Affairs bears the responsibility to ensure that it complies with the constitutional principles, values as enshrined in both Chapter 2 of the Constitution, but the entire Constitution itself. So as it relates to a unitary legislation, it will be very difficult, and it may in fact be unconstitutional if we were to not recognize marriages that have been concluded in terms of other beliefs or sexual orientation and so on. So we believe that the bill really goes through all the lengths to ensure that everybody is recognized irrespective of their sexual orientation and to comply with what the Constitution itself requires of the department or requires of the state as it relates to protecting, as it relates to fulfilling the rights that are contained in the Bill of Rights. So, Chair, Honorable Ross, we believe that the definition as it appears in clause 1 of the bill, which deals with what is meant by a polygamous marriage, we believe that that definition read together with clause 6 2A, that it is sufficient enough to deal with the issues and to ensure that we are recognizing polygamous marriages because they are grounded on a particular religion and they are grounded on a particular custom or on customary law. We other beyond the definition and beyond clause 6.2, we believe that there is no impact and that if the definition as it is and read together with that clause should be sufficient to clarify that we are not intending to introduce polyandry, that polygamy is as it is understood, and we do not therefore need to specifically state it somewhere, say for what appears under those sections. Honorable Maji, when we came to, let me start here. The current Marriage Act requires that a marriage officer must submit the marriage register within 5 days. Marriage officers themselves, when we were developing the marriage, the white paper on marriages in South Africa, were the ones who were submitting that we need to increase the number of days to allow them to submit. And it became apparent and clear when we were developing that policy that the 14 days is the preferred and reasonable period, and that the period is sufficient. And we believe that the 14 days is so sufficient that if anything were to happen a month later, at least the marriage would have been registered. And I think when it comes to access, Honorable, you would recall that the department is not only having the physical offices, that we also provide mobile services through our mobile trucks, and this would then deal with the issues relating to access. We just need to consider, and I think DDG Mavuso as well as DDG Sigama are also present. If they would want to further expatiate on this, they would be able to deal with this further. But we believe that the period is sufficient enough. And of course, Honorable Machi, this, as we had indicated, fraudulent marriages requires a whole of government approach, and it will need us to really pose the legislation to ensure that our enforcement mechanism is up to par to deal with this area related to fraudulent marriages. And when it comes to objections, as we have indicated, Honorable, we are going to, there is an obligation on a marriage officer, because the obligation, the objection, it's lodged with the marriage officer. The marriage officer bears the responsibility to investigate the authenticity, but also the truthfulness of the objection. Then we will then be able to guide through the training and the training manuals what they would then need to do in order to investigate whether or not it's frivolous or whether or not the objection is such that they cannot proceed with the solemnization of the marriage. But just to say at the level of the legislation, we just need to set a general principle and indicate that whoever wishes to object to the solemnization of the marriage must be and should be allowed to raise an objection, so that, and then the marriage officer would then be obligated to determine the veracity of such objection. And I think we, Honorable Machi, we had indicated that when it comes to us as public servants, somehow, our, rights as they are contained in the Bill of Rights are sort of limited by virtue of us occupying the offices that we have. And in that respect, Honorable, we should not be able and we should not be allowed to then say, I can only provide a public service to a particular category of persons, because the other particular grouping, it is, I cannot give them public service because whatever that they are doing, it's against my belief, it's against my religion, or it's against my culture. Surely there has to be some form of limitation when it comes to that, by virtue of the office that we occupy and by virtue of the obligation that we need to provide public services without discrimination. I think, Honorable Ngobeni, we would not agree with you more. We have agreed with what you have indicated, and safe to indicate that we need, post the promulgation of this legislation, up the ante to deal with with marriages of convenience, to deal with transactional marriages, to deal with fraudulent marriages. But on the other issues that you have raised, we agree with you fully. That not unless if a ward councillor it's also a pastor, and then he applies through the religious denomination or the cultural grouping that he belongs to become to be designated as a marriage officer, and then we will designate that individual as part of the religious denomination, not as part of his or her appointment as a ward council. So we fully agree with the submission. Chair, let me pause here, and through you, maybe Chair, you would allow then the Director General or the Deputy Director Generals who are present to deal with the other matters that I may not have dealt with. Thank you, Chair.
Thank you very much, Advocate Malikat. DTG Mavuso, is there any other matter or addition?
No, Chair.
Thank you, Chair, and thank you, honorable members. DDJ Mavuso, I'm not sure if you've got anything from your side.
No, thanks, Chair. Thanks, DG. No, I don't have anything on my side, Chair. Thank you.
Chair, can we proceed?
Thank you, DG.
Oh, okay. No, thank you, Chair. Thanks, DDJ Mavuso. I think, Chair, the earlier proposal for inviting COCTA is supported from our side. Definitely we will come back and listen to their views. As for the percentages, Chair, that Mr. Adams earlier shared, it's very difficult to comment without having been privy to the methodology, and particularly the scientific methodology that he would have used, or any tool of analysis that he would have used to come to those percentages, whether it's in the form of a survey or a sample size, including your margin of errors. So it's quite difficult for us to comment based on that without the necessary evidence to support the variations in the percentages. I think the last one, just to remind Honorable Rose that you will recall that the issue around polyandry and polyamory or polyamory were issues that had been canvassed in the earlier concept paper And when we went out for public comments, that fell off because there was no further support in the engagements that we had in all the provinces and also in the submissions that were made to the department. So let me pause here. Thank you so much.
Thank you, DG and your team, and thanks, honorable members, for interacting with the two reports. What will propose that we allow the department to interact with the COCTA or Department for Sports on these issues that have been identified in their presentation. We'll then have to work on our content advisors report and give members an opportunity, now that we have received the report of the content advisor and the Department of Home Affairs, to go back and work on that process of engaging perhaps a further consultation whilst we are waiting for Department of Home Affairs to come back. It will be important that DG, you interact first with the department, and therefore once they are ready, you come back with the department for a joint presentation, just for clarity, so that at the point that members are going to consider the report and deliberations on some of these issues, we're clearer on the matters. The second point that I will probably also recommend is that we will have an in-committee with the legal team of Parliament, just to deal also with these two reports now that we've noted them, to prepare for the engagement with both the either sports or COCTA and the department on clarity and how we're going to facilitate a discussion from that point, or there will be a need to introduce, or a need for them to introduce a legislation from that point. We do all this so that we are careful on how the committee process this legislation. I think we've carefully listened and noted the views that have been carried by all stakeholders, members of the community, traditional, religious, political parties, and those that are in Parliament and those that are not in Parliament. And it will be important that the committee conclude this point of the legislation. That also will assist us to also determine, and I got a sense from our last interaction that the legal team, they're also preparing to request for an extension, if I got them correctly, around this subject matter, so that we're able to allow the National Council of Provinces also to consider this process. I think we've noted these two reports. We'll then move in that direction, and we'll come back in the and as an urgent matter, as you've highlighted, as the speaker has highlighted, that we need to facilitate this bill. It is important also to know that we could not rush this consultation process, given the nature of the issues that we're dealing with, and it's important that we at least find a way to deal with this matter within the framework of the Constitution, and also the issues that accompany the process of a consultation. We'll then have to amend our response, the speaker, on the two issues once we engage in MENCO. Thanks, DG. Deputy Minister, I'm not sure whether you want to have a closing remark on the subject matter.
Not really. Just a few issues, Chair, as blanket covering issues. One is just to indicate that the religious and cultural rights, how we view the process, they must never trample on other people's right, and no religion should be seen as more superior than the others. What guides us throughout this entire process is the overarching law, which is our constitution, and it must never, at any given point in time, be ignored. As such, we follow that. And the issue of identifying marriages of convenience, I think it's a serious issue that we have been raising as some of the worrying factors that are coming up. And how we deal with it is that we have a number of internal control mechanisms that we have to follow through before we register any marriage. We have to do interviews, we have to do visits, and so on and so on. But what seems to be lacking is around the issues of public consciousness not to enter those marriages, because if the two people involved in them create an understanding between themselves, it becomes very difficult for us. Communities must just understand that entering into a marriage of convenience, you are actually defrauding the state, and that comes with serious consequences. The issues around increasing our access, we remain committed to increasing access not only for marriages, but for us to be able to have vaster reach to all our citizens. But I think we take your guidance, Chair, and we'll move as such. Thank you very much.
Thank you very much, DM. We'll then step off this item. We'll also release the department. If there's no any other item, Mr. Matonsi, that the department have to deal with?
No, there's no other item, Chair.
Okay, thank you, DM. Thank DG and your team. You can be released so that we deal with the last item on the agenda.
Thank you, Chair.
Can we move to the last item?
Chairperson, the last item is adoption of the minutes. These are the minutes of the 15th of July, where the IEC briefed the committee on the 2024 National Provincial Election Report. And then also they also updated us on the electronic voting, political party funding consultation and discussion, and then some issue of corruption against one of the commissioners. These are the members who were there in the meeting. Okay, I'll just move down. Go back, I'll go down to the bottom.
Sorry, Mr. Matonsi,
Yes.
if I may, Chairperson, if you go up, I think 2 pages. Firstly, there's a word there, data capturer. Just for so let's start with this page. Let's start with this page. The second last paragraph, their activities. If you can fix that.
Okay.
Activities and not attitude, whatever that is. And then up above there is data capturer. Look at simplified there. Might as well fix. Go up.
Okay, let me see.
That's simplified. Yeah. Maybe fix that as well.
Yeah, thanks.
Okay, simplified. Then data capturer does not need to be in a capital C.
Okay, let me just.
There you go. You're
Oh, okay, no, I'm just.
Sorry, that much. Let's try to go as slow as possible. The first paragraph, yeah, just fix those things. So for complete.
Okay, no, I'll note it and then I'll just change
devices. Yes, maybe if you just go through spell check for the entire document.
Yeah, I'll do that.
Thanks.
Okay.
Any other comment, members? Okay. Can we now move for the adoption of the minutes? With the correct.
I can move.
Thank you, Honorable Goveni. Seconder?
Chair, I'll second. Honourable Ruth.
Second, Honorable Ross. Which will mean that part of the issues we must deal with when we meet the IEC in MENCO is the update on the current discussion on the party political funding. Can you move to a second minute?
Yeah. September, it was the strategic planning section that we had for our strategic plan and the annual performance plan, where Dr. Mavuso Msimang also briefed us on the issue of Vulindlela. These are the members, Chair.
Comments, members, on the minute?
Okay, move down.
Noted this a long outstanding bill of government printing works. We managed to get a sense what is the update around it. When we meet when Dr. Lewis is going to give us an update on the issues that related to government printing works, I'll suggest that we also get update on this bill that they've been briefing the committee for a period of time. If there's no other comment, members, can we consider the minutes?
I move.
Thank you, Honorable Ngobeni. Seconder?
I'll second, Chair.
Thank you, Honorable Ross. Minutes considered. Can you move to the minutes?
16 September, we were briefed by the Parliament Legal Service on the one-stop border post, and then we did the deliberation. And then also we're briefed by the State Law Advisor and Parliament Legal Advisor on the certification of the marriage bill, the one that we just dealt with. Then there was also the briefing by Parliament Legal Service on the legal opinion on Phil Craig. We also considered the report of the 2024 national provincial elections for consideration and adoption. And then we also considered the strategic plan and annual performance plan of the committee. Yeah, those are some of the issues that were dealt with on that day, 16 September.
Thank you.
These are the members.
Comment on the minutes? Noted. On the issue of okay, can I invite members to consider the report, the minutes? I mean.
Yeah, on my side, Chair, the minutes looked fine on my side. Thanks.
Thank you, Honorable Ngobeni. In seconder?
I'll second, Chair. Nicole Bowman.
Thank you, Honorable Bowman. On the minutes, I think on the tracking, we must follow there's a report. In our last meeting, it was discussed. I think there's an update. We'll await the minister to brief the committee in relation to the matters that are raised towards the Director General. Secondly, on the elections, 2024 provincial and national elections, we've requested that the department must, no, sorry, the IEC must give us the review on the challenges that members of the community have raised in process of registration. Section 22A, capital A, on the voting pattern. So this is an update. When we meet the IEC, we may request that they update us on its impact and also its positive impact on the processing of legislation. And I think this also will assist us to prepare for the upcoming elections in 2029, or if there's any other amendment need to be considered, Parliament may need to take note of that. Can you move to the 4th minute?
Chair, it's 10 October. Were briefed by the National Treasury and Parliament Legal Service on their engagement on the one-stop border post in relation to Clause 6. And then the Department of Home Affairs and the BMA on their annual reports. And then also briefing by the Department of Home Affairs on the rollout of the self-service kiosk and the bank services to members of the public. These were the members there that were in the meeting.
Thank you. Comments?
I have one comment, Chairperson, to Mr. Matonsi, if I may.
Proceed, Honorable Ngobe.
Thank you. Mr. Matonsi, what does it mean if you capture members present and there's an apology and then there is absent is none? Is that because the member arrived late? How do we read that?
It means there was an apology, and then the other members were in the meeting, so then there was no one who was absent. Even though because there's an apology already here.
Okay, I don't know if that it's ambiguous in my view, but I don't think it's material. Thanks.
Okay, well, I can suggest that maybe just to remove the row that says absent, and then we only remain with members that are present and apologies.
I think that will be helpful.
Chair?
Thank you, Honorable Ngobe. Honorable Ross.
Chair, the way I interpret it is you're either there or you've given an apology, or you're not there, you didn't bother to give an apology. So that's the difference between being absent and apology. Apology, you're not there, but you gave you submitted an apology. Absent means you didn't submit an apology, you just didn't pitch.
Noted. Any other comments? Okay, members, can you consider the minutes?
I'll move for the adoption, Chair.
Adoption.
Any seconder? Thank you, Honorable Machi.
Thank you, sir.
On the minutes that the committee has resolved that it must follow up on the process of when we meet with the committee, when we deal with modernization and IT in the 4th quarter, the department must give account on this matter that relates to the self-services kiosks, the decision of the committee, and recall that the department has been updating the committee in relation to how they're going to distribute these kiosks, and also contrary the last engagement when we had the minister, there was a different views around the subject. So we need to engage with the ministry. The bank's issues that the committee also requested the minister to brief the committee again on the distributions and the timelines. You recall that in our last engagement, they did indicate that there's certain sources or tools that they've ordered that will also assist this distribution of or installation, so that these banks are also effective to assist the Home Affairs. I'm aware that there was a introduction of one of the banks to or launch to facilitate the work of the Home Affairs. So in our next intake, we'll also deal with the subject matters. Can we now move to a last minutes? We agree that each and every committee will deal with 5 set of minutes. Can we move to a last minutes?
The last one, Chair, is 21 October, is where we consider the issue of the letter from the Chief Justice regarding the filling of the vacant post of commissioners. And then there was a close deliberation on the one-stop border post, consideration and adoption of the BRRR for 2025, and then also update on the public hearings for the Western Cape and the Limpopo province at that time. These are the members who were in the meeting.
Thank you, members. Any comment? Okay, can we consider the minutes?
Yes, Chairperson, I move for the adoption.
Thank you, Onamachi. Seconder?
Seconded.
Thank you, Anungobe. Thank you, members, for having considered all the minutes and also with the corrections that have been made. What we'll request from the team is to track the recommendations as I've highlighted in each of the minutes that we've adopted. The committee has resolved that we must track our recommendations in terms of implementation in any other matter that is related to the decision of the committee. We request that in our next committee meeting, when we come back from constituency period, we also deal with the recommendation in the framework that we need to take as a committee on specific issues that we have identified as the committee. And we'll then move to note that we'll have a MENCO, as we've decided earlier when we opened the meeting, to deal with some of the legislative issues that we must brief the committee in our next meeting with the Border Management Authority when they brief us on the preparations for Easter weekend. We thought that it's important that the committee at least get a sense of the work that has been done, the limitations that they may face, but also what are the mechanisms in place that the Department of Home Affairs and other law enforcement agency led by Border Management Authority will assist in the preparations for the Easter weekend. Is there any announcement, Mr. Matonsi?
Chairperson, the announcement from my side is that, as we just indicated now, I'm going to be applying for a meeting for Thursday for the BMA to brief the committee on their Easter plan. And then that will be, we're going to be looking at in the afternoon after the sitting of the National Assembly. And then also that Chairperson, the Electoral Reform Consultation Panel report has been referred to our committee and also to the Select Committee in our program for the first term. And then next week, Tuesday, we have requested that we get briefed on the report. And also, Chairperson, since we don't have I think the sitting of the National Assembly, I was just thinking that maybe we should just do a virtual meeting for the 31st. Thanks, Chair.
Members, we agree that on Thursday, we've advised the team to apply, because Thursday is virtual mini plenaries. They start at 2 and end at 4. So we have requested, and we know in the morning, members engage in their political parties caucuses. We then have to apply for a virtual meeting with the department on Thursday. We had proposed that we must meet with them at 2 o'clock. And what COC allows us to deal with that. We'll then have a way to interface with the NCOP Select Committee to check their program. My understanding is that this is the last week of parliamentary work, but we'll have to get their schedule first so that we can confirm when are we meeting with the panel to brief the two committees, and then we'll be able to take it from there. Thank you very much. If there's no any other item, the meeting stands adjourned. Thank you very much, members.
Thank you, Chairperson.
Thanks very much.
Thank you, Chair.
Bye, everybody.
Bye-bye.
Bye.